The founding fathers foresaw no role whatsoever for corporations in America's political system. So the role that we all live with of powerful corporations and corporate interests dominant in our democracy is a creation. And it's a creation that has happened recently in my lifetime. What has happened to the court has been a judicial version of agency capture. So the Disclose Act, which cures that, is not only popular on our side, it's incredibly popular on the Republican side. There's literally nobody who isn't funded by corporate dark money who doesn't want corporate dark money out of politics. And I'm constantly saying originalism is bogus and it's phony, and it was reverse engineered to get results that the big donors who propagated originalism wanted. And by the way, the Supreme Court doesn't even follow it when it doesn't like the outcome. I don't think you're supposed to have a judicial philosophy. You're just supposed to have a good open mind and ability to read and think closely and decide the case in front of you fairly and without outside influence. I think that kind of does the trick. So I have a thesis, which is that the Supreme Court is not only behaving out of line with regard to the way it should behave, but it's behaving out of line with regard to what the rest of the federal judiciary does, and that the rest of the federal judiciary is starting to get a little bit fed up with the antics of the Supreme Court justices, which they know perfectly well would not be permitted to be done by them. There's a very dangerous loop if corporations are influencing judicial selection when it's judges who are in theory the watchdogs over their antitrust and monopolistic behavior.
Hi everyone, good morning. My name is Morgan Hurst and I'm a 2L here at Harvard Law School. I am beyond excited and honored to introduce Senator Sheldon Whitehouse to you today. Senator Whitehouse has devoted his legal career to serving the public in Rhode Island, advocating for the environment, and exposing corrupt corporate practices and undue corporate influence in our judiciary and legal system. The senator began his career in the Rhode Island Attorney General's office and then the office of the governor, later becoming the U.S. Attorney for Rhode Island in 1994 and the Attorney General of Rhode Island in 1998. As U.S. Attorney, Senator Whitehouse won a state record level of compensation for a massive oil spill in Narragansett Bay and directed those funds towards the affected citizens and bay conservation efforts. As Attorney General, Senator Whitehouse took on manufacturers of lead paint to hold them accountable for the lead poisoning harming Rhode Island's young children. In 2006, Senator Whitehouse was elected to be a U.S. Senator for Rhode Island. During his tenure, Senator Whitehouse has proven to be a fierce environmental advocate by co-founding the Senate Oceans Caucus and the Senate Climate Action Task Force. And beginning in 2012, Senator Whitehouse has delivered weekly speeches entitled Time to Wake Up on the Senate floor to advocate for action to address climate change. The senator has been a pivotal and unremitting voice for the environment in the Senate. And as this crowd is well aware, Senator Whitehouse is also the leading and absolutely critical voice in the Senate advocating for campaign finance reform and the need for action to counteract the devastating effects of undue corporate influence and dark money in our Supreme Court. Senator Whitehouse's two books, Captured and The Scheme, respectively detail the corporate capture of our democracy and how the decision in Citizens United has allowed powerful interest groups to use anonymous dark money to corrupt the judiciary and especially our highest court. Senator Whitehouse is not only an unrelenting advocate to expose these issues, but he has repeatedly presented a plethora of solutions, including his Disclose Act, Amicus Act, and most recently, the Supreme Court Ethics, Recusal, and Transparency Act. As chairman of the Judiciary Committee's subcommittee on federal courts, oversight, agency action, and federal rights, Senator Whitehouse has held numerous hearings on corporate capture-related topics, such as how we can take on dark money through increased disclosure requirements, and the importance of uncovering corrupt practices of major corporations such as Johnson & Johnson. And as the newly appointed chairman of the Budget Committee for the 118th Congress, Senator Whitehouse has pledged to make examining the economic consequences of climate change and the misdeeds of the fossil fuel industry chief among his priorities. I had the immense privilege of serving as a law clerk for Senator Whitehouse during the summer of 2022 and most recently during my January term. Senator Whitehouse's advocacy and initiatives captivated my attention after examining corporate capture so closely in Professor Hansen's torts class. Upon the conclusion of my summer clerkship, Senator Whitehouse encouraged us to return to law school with a critical eye towards corrosive corporate influences apparent in our classes and experiences. Inspired by that directive, I'm currently working on an independent paper supervised by Professor Hansen and his writing group, The Problem of Corporate Power. Senator Whitehouse and his team of counsel have played an extremely influential role in my law school experience thus far, and therefore it is truly my honor to introduce the Senator to you all today. If you haven't already been exposed to the Senator's work, once you have, you will find yourself a massive admirer, as I am. And with that, I give you the Honorable Sheldon Whitehouse.
Thank you, Morgan. It is nice to see you again, albeit electronically. And thank you for that wonderful introduction. I would start off by perhaps stating the obvious, but sometimes we shoot past the obvious, and it's worth pausing on it for a minute. And that is that the founding fathers foresaw no role whatsoever for corporations in America's political system. There's nothing about them in the Constitution or the Bill of Rights. They were never a topic of the Philadelphia debates. They're mentioned, I think, 3 times in the full of the Federalist Papers, referring to little municipal corporations, not the type of corporations that we now know. So the role that we all live with of powerful corporations and corporate interests dominant in our democracy is a creation. And it's a creation that has happened recently in my lifetime, and it has happened entirely at the hands of Republican appointees to the United States Supreme Court. It is something that we should not overlook as we have the rest of this discussion. So in the various jobs that Morgan listed, I was often very busy, but I wanted to keep my hand in as a practicing lawyer. And appellate work was a way to do it, because you could do the reading and the briefs and the research at night. Argument day was just a day. It wasn't like being stuck in trial for a month when you're busy doing other stuff. So I did a fair amount of appellate work. And from the Senate, the behavior of the Supreme Court just began to seem weird. And so I flagged it, and I flagged it first in an article that you can look at that I did for the Center for American Progress. And what it looked at was civil cases, because that's where the mischief lies mostly with the corporate sector. And the 5-4 decisions that broke along partisan lines with the Federalist Society judges all together on one side. And there were, I want to say, I'm not going to get the numbers right, but let's say there were 78 of those cases. When we scrolled through them, we could find 72 of them in which there was a really obvious benefit to a big Republican donor interest. And so we dropped the other 6 and looked at those 72 to see how the cases came out. Well, it turned out it was a 72-0 rout for the corporate interests. So that seemed to me to be a signal that something was really wrong. The speeches that Morgan mentioned that I do on the Senate floor about climate started with, polar bears and pteropods and flooding and all that kind of stuff, but they quickly morphed into looking at why we were where we were and looking at the apparatus that is behind climate denial, which has been actually studied by quite a lot of people, including Harvard's own Naomi Oreskes. And those scientists and researchers have figured out that there are probably 6 or 8 dozen front groups that are played kind of like piano keys by the fossil fuel industry to put out the propaganda and the argument about climate change, first being a hoax and then being too expensive if you fix it and so on. So from that experience, I also had this sense of what's going on behind the scenes and to look for the apparatus. So weirded out by where the court was going and by the 72-0 record, we started looking back a little harder at the machinery of the capture of the court. And I say that word capture very precisely. If you go to the Harvard Law Library, you will find lots of research, both in the administrative law and economics sections, about regulatory capture, also called agency capture. Goes back to the bad old days of a bunch of robber barons, who were running a railroad, taking over the railroad commission with their flunkies so they could get the rates and the terms that they wanted. What has happened to the court has been a judicial version of agency capture. And the more you look at that apparatus, the weirder it gets. I don't know if you can post the picture that I asked to have ready to be posted. I'm not at all capable on the, okay, so there it is. So there's a guy named Leonard Leo who's been extremely active in the Supreme Court appointments mischief. He was the guy who helped orchestrate Harriet Miers getting knocked off as the nominee of President Bush, who was his personal friend and White House counsel. So it's no small thing to humiliate your own president and force him to withdraw a Supreme Court nominee he has announced. But he pulled it off and filled the vacancy that knocking her out created with none other than Sam Alito. The little top is his little group of corporate entities through which he gets himself paid. And they connect with the bottom group, sort of like the torso of the bug, if you will. And this is kind of an interesting set of groups. If you play politics these days, what you do is you set up a 501c3 and a twinned 501c4 with the same offices and the same officers and the same, almost virtually indistinguishable. A corporate veil you could pierce with a banana. And so he has 85 Fund and Concord Fund, which are his two 501c3, 501c4 twins. Now, each of them operates also under what under Virginia corporate law are called a fictitious name. So it's the same entity, but it's allowed to operate under a different name called under Virginia corporate law, a fictitious name. And on the 85 Fund side, it's the Judicial Education Project, the Honest Elections Project, and Free to Learn, which is how to get people excited about critical race theory and all that stuff. On the Concord Fund side, it's the Judicial Crisis Network, the Honest Elections Project Action, and Free to Learn Action, the 501c4 politically active side. So look at Judicial Crisis Network. They're the ones who spent tens of millions of dollars getting Garland stopped and Gorsuch and Kavanaugh and Barrett onto the court. They were receiving checks for as much as $17 million, which is a pretty good sized check. And they were not disclosing the donors of those checks, and they were turning the money around in the TV campaigns, pitching the arguments that they had against Garland and for Gorsuch, Kavanaugh, and Barrett. So when you see all of this, you see that there's a lot more going on than just stacking the court, but the Judicial Crisis Network was essential to that, conveniently located down the hallway on the same building, on the same hall as the Federalist Society, which was the venue where all of the recent Trump nominees were selected by some anonymous group of patrons in a back office operation that had no apparent rigor or transparency. It was just a question of putting the fix in. So that's the kind of stuff we're up against. This is just part of his deal. He has a whole other bunch of entities, one of which is a Utah front group that just received a $1.6 billion contribution from a right-wing billionaire. So this guy is locked and loaded to cause a lot of mischief for a long time. So let me wrap up with kind of that overview of what we found. Let me say that there are a couple of areas where I think law students can be very helpful if they direct their attention. The first is the unexamined question of appellate fact-finding. It's pretty clear that appellate courts aren't supposed to do fact-finding. That's what the district courts are supposed to do. If you think about it, there's a pretty strong constitutional case or controversy argument for why you would want to separate the fact-finding function at the district court from the sort of legal policy-making function at an appellate court. and make sure that you're snubbing the policy-making folks down to real facts in a real case or controversy, so they can't make up facts and thereby change or manipulate the case or controversy. And some of the worst decisions of the Supreme Court, like Shelby County and Citizens United, have stood on not only appellate fact-finding, but appellate false fact-finding, and appellate false fact-finding that later events have revealed to be spectacularly untrue. And in very telling fashion, the Supreme Court has refused to go back and clean up the decisions that stand now on a false predicate of false facts, i.e. they stand on nothing other than the continued determination of the Supreme Court to leave them out there as good law. So that's one. I'd also encourage you to keep looking at and test my proposition about the pattern of their decisions. I think if you were bringing a bias and discrimination case into trial and you had the kind of track record of pattern that the Supreme Court has shown, you'd have a really good time in front of a jury, and your opposition would likely be in settlement discussions with you. 6-3 now versus 5-4 makes the math a little weird, but I encourage you to keep looking at the pattern of decisions and how they relate to the amici curiae. Which brings me to the amici curiae, because what the right wing does, having packed the court with these judges, is to send in little flotillas of front groups that have no real purpose in life other than to get involved politically for their secret donors, and file little flotillas of amicus briefs. And I spend a good deal of time filing my own amicus briefs that point out the other side's amicus briefs and how they're commonly funded and how they haven't reported that, and what some of the mischief is that the others are up to. For instance, in the recent case on the legislatures taking over elections, the Honest Elections Project, which you'll see in the middle leg of the bug on the left-hand side, is essentially the same corporate entity as the Judicial Crisis Network. So it showed up without disclosing that its corporate twin had spent tens of millions of dollars to get these justices on the court, which at least raises an issue under the Caperton doctrine, but undisclosed, it just lay there. So I had to point that out. And the last thing, which I'll just touch on briefly because it's too much to get into now, we'll go to questions, is the persistent problem of the Supreme Court having no ethics code and no ethics process, and an ethics review that is accomplished in violation of the ancient dictum, so ancient that it's in Latin, nemo judex in sua causa, nobody shall be a judge in their own cause. And yet they are judges in their own cause, and they're violating very, 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 very plain strictures that apply to all other federal judges. And I think the more that gets dug into, particularly the comparison between how the Supreme Court behaves and how other federal judges are treated, I think all of that lends itself to a lot of good work to draw out the distinctions there. So with that, I'll leave it to questions.
Can you hear me? If anyone has questions, please raise your hand and I can direct the microphones to be brought to you. Okay, I'm going to start with one while everybody's thinking about their questions.
Sorry, that was a pretty fast download.
No. Senator, thank you again for being here today. We're all really excited to have you. Maybe the crowd would enjoy hearing a little more about some of the proposals you've put on the table for the increased disclosure requirements, like the Disclose Act.
Sure. Well, the Disclose Act would require anybody who spends more than 10 grand in an election to disclose who they are. I think it's pretty obviously good. It's the issue that my hero, Jane Mayer, in one of her New Yorker articles wrote about. She's just amazing. She somehow got her hands on either the tape or the transcript of a discussion between Mitch McConnell, the Republican Senate leader's political minions, and the Koch brothers' political minions. And they were talking about an issue that was really ruinous for them. And no matter how they tried to smear it and twist it, they couldn't make it work for them. It was just a disaster. And that issue was big corporate dark money in politics. So the Disclose Act, which cures that, is not only popular on our side, it's incredibly popular on the Republican side. There's literally nobody who isn't funded by corporate dark money who doesn't want corporate dark money out of politics. So the more we can press on that, the better off we will be. And that's my Disclose Act bill. We're also working on transparency around the Emmy key. The Supreme Court rule is read with the permission of the Supreme Court as requiring that you only disclose who funded the actual printing, distribution, and service of your brief, which is probably a $5,000 or $10,000 operation. And a lot of groups have that in petty cash. They don't have to raise it specifically, so they disclose nothing. But it turns out they're wholly funded by the Bradley Foundation or by an entity pushing money through Donors Trust or something like that. And if you dig a little, you find that in a given case, there are 10 or 12 who have the same funding. We actually did an appendix in one of my amicus briefs pointing out the overlay between funders and amicus briefs on the other side. And then there are some ethics disclosures that need to be cleaned up. Justice Scalia took the position that if you sent him a personal invitation to a resort and offered him a free vacation at your resort, that did not have to be disclosed to anybody because it was personal hospitality. Now, I think personal hospitality means that you have a personal relationship with the host, not that somebody invited you personally, particularly somebody you've never met. So there was a lot of mischief that was done with his hunting trips to hide them using that scheme. So there's a lot of stuff like that where a little transparency would be very healthy in and around the court. And of course, in the Disclose Act, I'd require Judicial Crisis Network to disclose their $15 and $17 million donors. I treat those ad campaigns as political.
Great, thank you. Okay, we have a question coming now from the crowd.
Hi, Senator Whitehouse. Thank you so much for coming and speaking with us. I actually used your book, The Scheme, and particularly your chapter on dark money, to inspire a paper that I wrote for Professor Hansen's The Flaw on this topic. So thank you very much for being one of the few politicians who's really trying to draw a lot of attention to this important issue.
Well, thank you for your work, because there's a lot to dig into. Keep at it.
So I have two questions. The first question is, in 2021, in the Supreme Court case of Americans for Prosperity Foundation v. Bonta, the Supreme Court seemed to indicate that they were having none of disclosure laws, even when they're pretty narrowly tailored. So I guess my question is, even if the Disclose Act or other proposed legislation were to pass, what is your confidence that they wouldn't be struck down by the court anyway? And how do you kind of deal with that issue? And then my second question is, according to ProPublica investigators, the issue of dark money has been historically dominated by Republicans, but in the last two election cycles, Democrats have actually attracted more dark money spending than Republicans, at least that we know of. And I think one of the big concerns there is if you're fighting fire with fire, you're just producing maybe a larger fire and going to make it harder for people to be willing to fight against dark money if they're becoming more reliant on it and dependent on it. And then the other concern that you're maybe creating dark money strategies that inspire the other side. So I guess what would your response be to the growth of dark money in the Democratic Party?
So all good points. First, on the Americans for Prosperity Foundation ruling, I'll come back to that and I'll close with a little bit more background on that, because frankly, that's worth a law review article of its own. It's just a very, very peculiar set of circumstances there. But I think it's really important that we not flinch from the shadow of what we think the Supreme Court might do. There's a lot of this, particularly in the environmental community. Oh, no, we shouldn't put too strong of an environmental reg out there because the Supreme Court might strike it down. Let them. Let's have that fight. We should do what we think is right, and when they cross us, then we'll have that fight. But shrinking from where we think they might go, I think, is terrible strategy. the Republicans have set the rules of political engagement around dark money. I believe they still outspend us considerably. If you look at the top Senate races recently in the swing states, Republican dark money just blew out our outside spending. And the important thing here is that while we have to play by their rules or get beaten, we're the ones who are trying to change the rules to get back to normal. And I think there's a case that can be made that politically, the public would really get behind that we're fighting to do this. I think we have to fight harder. I think it was a shame that for the first, 15 or 16 months of the Biden administration, he used the term dark money only one time, once, buried in a long sentence someplace. I think he should have come in as the, avenging crusader to battle the dark forces of corporate mischief and made that a theme from the very beginning, but he didn't, and there we are. So quickly back to AFP, just to point you in some different directions. Look at how long that case, first of all, remember my Leo bug and the 501c3, 501c4 side by side? So Americans for Prosperity Foundation is the 501c3 twin of something called Americans for Prosperity, which, as all the Federalist Society justices know, is the main battleship in the Koch brothers' armada of political influence. It is a big, big monster. So pretty clear who's really here. This is the Koch brothers. Then the thing sits awaiting the court taking it up. It sits on the docket for a long time, way longer than usual. Doesn't get knocked off, doesn't get taken up, just sits. Then comes January 8th, when the entire country is looking elsewhere, January 6th having just captured the attention of the entire world as the Trump folks ransacked the Capitol. And on January 8th, suddenly, boop, here comes the case onto the calendar. And the next thing you know is that at the certiorari stage, the phony front groups show up. And they usually show up in flotillas of about a dozen. In this case, at the cert stage, they showed up 50 strong, 50, sending a very powerful message to the Federalist Society judges. Hey, guys, this is a big one for us. Don't mess around. And then you came up with this very peculiar decision that overruled the states in their ability to test for fraud by looking at who are the big donors to tax-deductible 501c3s. Is it legit? And they never dealt with the problem of Citizens United, saying that if it has to do with politics and it's anonymous, it's corrupting. That was one of the basic premises of Citizens United. They just walked right by that and let this highly political 501c3 have a brand new constitutional right to hide its donors. So yes, I think we have to look at Americans for Prosperity Foundation versus Bonta as a prairie fire that has just gotten started. And the sooner we can stamp it out, the better. They make the most appalling comparison I've ever seen a court make, comparing mega billionaires who hide behind dark money front groups to try to influence our politics in ways that they can't get democracy to do, with ordinary members of the NAACP in the late 1950s Jim Crow South, that they are equivalent, and therefore the case that said that Alabama couldn't have the member list of the NAACP is exactly the right principle to apply when you're dealing with the Koch brothers and their vast influence armada.
Thank you. Does anybody else in the crowd have a question? Yes. Sean's going to run you a microphone.
Hi, can you guys hear me? Thanks again, Senator, for attending today, and thanks for all the proposals that you're coming up with to fix the process and like how the court is captured. Quick question on the Supreme Court nomination hearings. They're kind of a farce. Like, they seem more like a avenue for...
You noticed.
they seem more like an avenue for politicians to paint the nominee in a certain light rather than get substantive answers from them and gain an understanding of what the candidates believe in. I know that the candidates don't necessarily want to answer the questions either because they can lose the nomination as a result of it. But do you have any plans to improve that process to encourage more transparency?
It's really hard to do, particularly where the circumstances around us are so peculiar. I think if we had good information about donor influence, if it was clear to everybody when, let's say, Kavanaugh was being confirmed, who had written the checks to the Judicial Crisis Network to run the ad campaigns for him. And we also had disclosure on the campaign finance side, so we knew who was funding Mitch McConnell's big outside spending machinery, the super PACs and all. Then it might have been clearer to the American public there was a little bit something more going on, but they were denied that information. And we were denied that information. So I think the Judiciary Committee and a Supreme Court nomination becomes the crucible for outside political forces. And if you haven't got disclosure about what's going on from those outside political forces, then the American public is really denied very meaningful and significant information. And of course, it's in the interests of those political forces to deny the public that information, but it doesn't change the fact that it's wrong. The other thing that we're looking at still in the wake of Kavanaugh in particular is the FBI background investigation process, because the FBI clearly took a dive on the Kavanaugh supplemental background investigation into Dr. Blasey Ford's accusations and the others that swirled around it. And it was very peculiar at the time because the FBI closed its shutters and pulled up the gates and made itself impervious to information. And having spent a lot of time around the FBI as Attorney General and US Attorney, that is not an organization that is usually impervious to information. They usually want information. It's their function to gather information. So repelling information was a very peculiar situation for them. And it turned out that what was happening is that they were under the instructions of the White House. They were not following any FBI procedure other than to do what the White House tells them. And as a result, the investigation only interviewed people who the White House allowed them to interview, told them to interview. And I believe also actually directed the scope of the questioning that was allowed of the witnesses who the FBI interviewed. And at the same time, the little peephole through which they allowed information in was a tip line. They allowed people to call in through the general FBI tip line. And what they did with that was to sort out all the information that was relevant to Judge Kavanaugh and box it up uninvestigated. Uninvestigated. They did not one moment's investigative work on any of those tips and turn it over to the Trump White House. So the Trump White House had the tip line information. It could look at what leads were most important and from their perspective, most dangerous. And by the ability to have that info and then direct where the FBI asked questions, they could make sure that the FBI didn't ask any questions of anybody who had any relevant, dangerous, or corroborating information. And we're going to keep looking into that. We've gotten so far, the director, despite intense FBI slow walking and pushback, we finally got Director Wray to admit that, yeah, in fact, the White House directed the entire investigation and the tip line materials went uninvestigated. So he's on the record under oath admitting to those things. So, you know, that's the kind of weird environment in which all of this took place. And again, if the FBI had done its job properly and followed actual background investigation procedures, the hearing would have been, I think, less dissatisfying to so many people.
Thank you.
Okay, we have a couple questions in the back. Oh, and one on the left.
Thank you. Senator, I noticed you started with the Federalist Papers, and I guess I feel like that's reflective of how infectious originalism has become to the way we think about the world and the way we think about law. And as you know, lawyers are not historians, neither are judges, and it seems pretty scary to me that we would base our world on what we could find in a 1700s dictionary. And so I'm curious both how you think we break the mold of talking about that, and then what language we should use instead of originalism, given how much it's permeated the discourse.
Yeah, I commend everyone Dean Chemerinsky's book, about maybe 6 months out now, called Worse Than Nothing. And it's a very thorough takedown of originalism. My Republican colleagues in the Senate are constantly mentioning originalism and asking people about their judicial philosophy. And I'm constantly saying originalism is bogus and it's phony. And it was reverse engineered to get results that the big donors who propagated originalism wanted. And by the way, the Supreme Court doesn't even follow it when it doesn't like the outcome. There is no decision that is less originalist than Citizens United. And that's why I go back to those early founding moments when it was clear beyond any dispute that there was no role whatsoever for corporations in American democracy. And here they are opening up, unlimited political influence for them. It makes no sense at all. How to talk about it better, I have not really figured that out, to tell you the truth. What I say in the hearings, and when I'm talking to the judges after they've been berated about their judicial philosophy not being originalism, is I don't think you need to even have a judicial philosophy. A good mind, a good heart, a good understanding of the English language and the ability to read the statute and the constitutional provision in front of us, and a desire to do the right thing, are kind of enough. This notion that one has to come to a court with a judicial philosophy, I think that's as imaginary as the doctrine of originalism. And it provides cover for a judge coming in and saying, oh, I'm originalist. I'm supposed to be an originalist because I'm supposed to have a judicial philosophy. I don't think you're supposed to have a judicial philosophy. You're just supposed to have a good open mind and ability to read and think closely and decide the case in front of you fairly and without outside influence. I think that kind of does the trick. So we'll see. Somebody else can come up with an actual better way of describing it, but that's as far as I've been able to get. But don't buy originalism, and Chemerinsky makes a very good rebuttal.
Great. Okay, I have a question over on this side and this side as well. We can do, okay, we'll do it on the right first, and then we'll go over here.
Thank you, Senator. I really appreciate the work you've done identifying the pernicious influence of corporations in capturing the federal judiciary. What I don't fully understand is how disclosure and transparency requirements actually combat that influence. Like, it seems to me that if Kavanaugh knew that the Koch brothers had funded 24 amicus briefs in a case, he would still be a corporate shill. He wouldn't change his opinions because he realized that all these corporations were funding the legal arguments that he was applying. So I don't understand the mechanism there that allows disclosure to combat actual influence instead of just allow us to understand that influence.
Well, you're absolutely correct about him. The difference is that we don't know. Right now, these groups show up 11 or 12 at a time. They deliver a message that is coordinated and in very harmonious chorus, and the court then follows it. And on our side, as observers looking at this mess, we have not done a good and thorough job of looking at the pattern of how these commonly funded entities all come together, what they all ask the court to do, and how obediently the Federalist Society judges follow their direction. They may not get everything they want, but the directionality is almost perfect across now probably 80 plus decisions. So if we were getting that information out and the press was reporting on it and academia was taking this into account when, debating Supreme Court decisions, and we weren't just lost in this fairyland of, oh, this is a very conservative court, which is simply not factually the case. If we were really addressing the problems there with factual information, I think that would put a lot of pressure on the court, and it would take some of the fun out of being a phony front group, because you'd have to report up who you were and who funded you when you turned up in the court. So it just provides added information into the ecosystem around the court, which in turn, I think, puts pressure on the court. I don't think there's anybody else who has gone through the cert briefs in Americans for Prosperity Foundation and sort of told the story of how it is that they came in with such a blare of alarm and noise to the court, and how they're connected. And in fact, there's lots of room for research there. But I think when the academic, legal, and press, legitimate press communities have access to that information, it will in fact move the court in a good direction. Or if it doesn't, it will build increased pressure for the changes at the court that we need. But it's not going to change the heart of Sam Alito, I can promise you that.
Okay, over on the left.
Hello, Senator. Thank you for coming and speaking with us today. Over the last 2 days of the conference, we've talked a lot about sort of the perceived illegitimacy of the court and how that's become an increasing problem in American society. And I'm curious whether you're seriously considering, alongside sort of these disclosure laws that you talked about, any kind of congressional reassertion of sort of dominance over the court, and whether there's any serious considerations of more sort of significant Supreme Court reforms, such as the idea of, rotating circuit court judges on like a set term, or things that would help dilute the possible influence of one or two people every 10 or 15 years, basically being able to swing the direction of the court.
Yeah, in addition to the disclosure and transparency and ethics bills that I filed, I've also filed a term limits bill that would rotate them off and have them go on to senior status, which does a couple of things. First of all, having a couple of judges on senior status in addition to opening vacancies provides a bank of judges who can come in, so that if somebody has to recuse themselves, then they lose the argument about staying on the case that, oh my, then we're not a court of nine any longer, and it's super important that we be a court of nine. So I think for a lot of good reasons, the term limits idea is good. If I can speak just politically for 1 second, I do think that my party tends to get ahead of its skis and produce solutions before we've done the homework of showing the American people why the solution is needed. If I'm a lawyer and I'm going to go into court and I'm going to ask a judge for extraordinary relief, it is on me to make the case first so the judge understands why that extraordinary relief is needed. And it's important, if you want to change sort of longstanding structures of American government, that the public understand that as well, so that they can't be frightened by the countermeasures from the people who are opposing us. So there's a due diligence, there's a homework required to get the word out as to why this matters before we launch ourselves at a change, having failed to do the homework. And the purpose of writing the scheme, and the purpose of my scheme speeches, and the purpose of the articles I've written and all this work is to push that forward so that we get to a position where the American public agrees, yeah, there actually really is something wrong with this court. This is not a normal court. And how do we fix it? Let's think about ideas. I lived through Green New Deal, which was all like extremely good policy. and the Republican right-wing fossil fuel propaganda machine just pounded it down our throats, so that by the time it got its first vote in the Senate, it was Mitch McConnell who was pushing the vote. So turns out in politics, like in courtrooms, there needs to be a correlation between making your case and asking for your remedy.
Any other questions? Okay, over here.
Hi, Senator Whitehouse. Thank you so much for being here today with us. Obviously, one of the most controversial cases the Supreme Court decided last year was June Medical. So I'm wondering if you see decisions like that strike reproductive rights from the lives of millions of Americans, how you see that intersecting with the corporate capture of the judiciary.
There is not a pronounced corporate financial interest that I can identify very well in women's reproductive liberty. But what there is a very powerful coalition of Republican donor interests who work together to get wins across the board. And better people than me have gone back and they've written about the marriage of convenience between the corporate sort of plutocracy sector and the far right social issues groups, so that they meld together and give the corporate forces the added energy of the rest of that base. And I think that it's been perhaps one of the most effective partnerships in political history. And so I see it, even though not necessarily directly valuable to any company's bottom line or to its ability to pollute or any of that, a very important part of the payoff and the series of victories that are necessary for that small, tight, powerful, wealthy coalition to accomplish its will. You get yours today, I get mine tomorrow. You get Dobbs, I get West Virginia versus EPA and Americans for Prosperity Foundation versus Bonta.
Okay, we have a question right in the center.
And while the question's being prepared, if you go back and look at Kavanaugh's pre-Supreme Court behavior, you can see him auditioning to these big donors for a Supreme Court position across that whole battery of issues. He knew perfectly well, having worked with Leonard Leo back when Harriet Miers was taken out and Sam Alito was put in, and not being on the original Trump list, he knew he had to really impress people in order to get onto the remediated list. And so he's like the living embodiment of the array of interests that you need to audition for, because he hit every single one.
Good morning, Senator.
Morning.
It sounds like what you presented today is something the Democratic Judiciary Committee could have spent the last 2 years investigating. And I'm wondering whether there's just some kind of separation. Wonder if there's some kind of separation of powers concerns, or whether really the Senate could delve into over the course of the next 2 years and exactly this kind of inquiry. What are your thoughts about that? Is there support and consensus for that, or is there some kind of corporate capture of the Democratic Party to the extent that they're unwilling to investigate those?
Well, I am the chairman of the courts subcommittee of Senate Judiciary, and Hank Johnson is the chairman of the court subcommittee of House Judiciary. And we've been working together for years now, ever since I got that sub-gavel, to investigate exactly these questions. And a good deal of what we know comes because of what we've focused on. It is hard to do this, and it is slow and kind of unsatisfactory going, because the Supreme Court is totally unresponsive. and hides behind non-answer answers. And even the Democratic appointees on the court allow that to take place without any evident internal dissent. So it's really, really hard to penetrate into, through that barrier that they have set up. But to your question about separation of powers, I do believe we can penetrate that barrier legislatively, which is why I've drafted these bills to force an ethics code on them and to require amicus curiae disclosure and to clean up their gifts and hospitality acceptance and reporting and all of those things, which I think are well within our rights to do. They will say, oh, no, that violates the separation of powers. But I don't think they'd say it would violate the separation of powers for us to require that of the executive branch. And I don't think there's a separate status for the judiciary administratively on ethics matters that we can't do within the judiciary what we can clearly do in the executive branch. So we are working on that as well. I will tell you that we have one interesting feature in all of this is that the Supreme Court will blow us off on stuff. And what I've figured out to do is to push the question to the Judicial Conference, which is the administrative body that runs the administrative side of the judiciary, which the Chief Justice chairs, which has the chief judges of all the circuit courts and various appointed district judges on it. And on two of these issues that we've talked about, on disclosing who the real funders are behind the amici, and on the phony baloney refusal to disclose free vacations because the owner of the resort invited you personally, after being blown off by the Supreme Court, I pushed those questions to the Judicial Conference, and they have agreed to take them up. And they've appointed committees in both cases to work through what they need to do to improve. So I have a thesis, which is that the Supreme Court is not only behaving out of line with regard to the way it should behave, but it's behaving out of line with regard to what the rest of the federal judiciary does, and that the rest of the federal judiciary is starting to get a little bit fed up with the antics of the Supreme Court justices, which they know perfectly well would not be permitted to be done by them. And so I have a feeling there's kind of a slow building, gradual counter pressure within the Judicial Conference out of some degree of dismay about the flagrant misbehavior at the Supreme Court and the flagrant sort of omerta about discussing any of it. So it's slow slogging, but we are making small gains and we intend to continue to.
Great. I think we have time for one more question, maybe the original and the question in the center.
Thanks. Thanks, Senator Sheldon Whitehouse, for being with us today. We really appreciate it. And
my pleasure.
And I appreciate your knowledge of history. But I would like to be the devil's advocate.
I got a Yale education.
I know. It's almost as good, but I have no education in the law.
Nearly as good, right?
Nearly. But founded by folks from here anyway, so close enough. In the interest of being the devil's advocate today, I really strongly disagree that corporations in particular were envisaged early on in our judicial process by none other. I think one of the most important decisions in this area is actually
Dartmouth.
Sorry, I'm going to go back to Joseph Story, the first Dane professor here, and I'm pretty sure you'll know the case I'm going to cite, trustees of Dartmouth College.
Dartmouth College, yeah.
Yeah, versus Woodward. And
yeah.
And I do believe there was a sense back then that we needed the capacity to accumulate large amounts of capital in order to develop this country. And I do believe we are way beyond that, the utility of this, and that in large part we're here today to try to figure out, how much of a mess has been made by what might have made sense, economically, maybe even legally at one point in time. And then there's the question of charters, and how does one revoke this power given to an entity that's essentially in perpetuity. It has no, how this is anything close to a person, I don't understand, or a living being anyway. So I guess my question is, going back to Harvard's involvement in this, and even Harvard's incredible accumulation of wealth and power, and frankly, very little oversight. Back to Nathaniel Bowditch's role in creating the overseers here, and the separation of the financial wherewithal of this institution from its role as a 501c3. So I won't go on much longer, but I think it's gone way beyond its utility. And I'd like to find out if you have any thoughts on how, either at a state or federal level, we once again retain control through the legislative process, which you're involved in, to try to limit the power of these corporations at a fundamental level and reverse. I think, frankly, maybe a good decision at the time, but a lousy outcome in the long run.
So I don't necessarily disagree with the Dartmouth case and with Daniel Webster's arguments in it, and that Dartmouth had the ability as a corporate entity to defend itself and stand up for itself and deal with the question of who got appointed to it. That's, to me, that's not necessarily the crux of the problem. And just to be clear, I have absolutely zero opposition to the existence of corporations. I think they have been a very powerful engine for economic development, for protection from liability for investors, for organization of economic activity, and all that kind of stuff. But the question is, where is it a trespass for them to go? And when you look at the size of some of the big corporations today, particularly the big platforms, so trying to keep corporate influence out of judicial selection has a very significant justification that requires us not to attack corporations per se, but to say that this is a no-fly zone for you. You should not be involved in this because you are not a person. You are not determined to be part of our political environment. The political environment that polices your behavior turns rancid if you're controlling, quis custodiet custodes. You can't be the watchers of your own watchmen. And then I think a similar argument applies to politics, that a CEO has plenty of advantages to get their wishes heard in politics. They've got more money than the average person. They've got more friends than the average person. They've got their employees. They've got their supply chain. They've got their customers. They got all sorts of people that they can say, hey, we really want you to vote with us against that rat Whitehouse because he's trying to make us stop polluting. And if they can sell that pitch, great, good for them. But what they shouldn't have is the right, in addition to their own personal wallet and their own personal megaphone, to be able to crank up their ginormous corporation and have that come cranking out onto the political field of battle. And I think the boundary of how far corporations should be allowed to go, obviously they should be able to defend their economic interests in court when they're sued and things like that. Where those boundaries are is something that I think law schools would be really, really usefully tasked to trying to refine and theorize about. But at the moment, we've more or less just let them run wild. So the precise theorizing about exactly where that boundary should be has not been adequately developed. So in a nutshell, you want to be a big corporation and go play in the economic sphere. We've allowed that for a long time. That is not my problem. My problem is when you try to dominate the judiciary, which is part of what you're policed by, and when you try to intrude into politics in violation of the we the people principle upon which the country was founded. That you shouldn't be able to do. And the more we can define that argument with more precision, the better off we'll all be.
Great. On that note, I think
So on that note, let me just say thank you all for your work in this space. There really is good work to be done. I hope some of my suggestions have fallen on fertile ground, and very, very much appreciate Professor Hansen, your leadership in this area. Morgan, thank you very much for that wonderful introduction, and you're always part of Team Whitehouse. And to everybody else, let's go out and win this fight. It's not an easy one, and we're not going to win it tomorrow, but we can win it, and the country that will emerge from that victory will be one we will like a lot more.
thank you, Senator Whitehouse.